All right, we are live. Welcome to the Ad Hoc Commission on the Discipline System ENEC Working Group. I will call the roll. Ed Lear.
Here.
Melanie Lawrence.
Here.
Linda Schneider.
Here.
Judge Wang.
Good morning.
Good morning. I will now call for public comment. If there is anybody in the public that might like to make public comment, please use the Zoom option to raise your hand and I will call on you. The current attendees look to be all State Bar staff, so I don't see a member of the public. So with that, we can proceed to today's agenda and I will turn it over to Ron B. Ron.
Good morning, everyone. Let me share my screen. So the short presentation I put together is a continuation of our previous meeting with some questions that I had to follow up, pulling some additional data. So here are the questions from our previous meeting 2 weeks ago. First, what is the impact of ENEC and council representation on case age? We looked at cases going through the stages before filing with the State Bar Court, broken out into ENEC, non-ENEC, whether they had counsel or not counsel. And then there was a suggestion that we should take out the cases that went to default because they somehow distorted the overall comparison. So that's the first part. Second, is there any relationship between the number of ENEC sessions and case outcomes? Case outcomes meaning settlement rate. Third is, what is the relationship between ENEC and discipline outcomes, including dismissal, ALD, reproval, and warnings? The last one is to look at criminal conviction matters in comparison between query and non-query cases in terms of their discipline outcome. The two tables here, the first one is what was presented last time. And I focus on the ones that's highlighted in the square. Previously, it shows the median time for cases with neither ENEC nor council representation. The median time is 355 days. When you compare the two groups, between cases that went through ENECs versus not, the total column shows the differences between 628 days for those that went through ENEC compared to those without is 423 days. Now, removing default cases affected primarily, when I look at all of these cases in the 4 different groups, they affected primarily cases with neither ENEC nor council representation. And that led to an increase of median time for these cases by about 60 days. That's what's shown in the second table below, where the original sample size is 442. After removing default cases, it dropped to 352. So the overall difference in median time between ENEC and non-ENEC cases show that ENEC cases taking 200 days longer, approximately, and with default cases excluded, difference dropped to 176 days, about a month. And this is what we looked at last time also, just presented data about case age, comparing the 4 groups in a slightly different way. The dotted line is the line representing cases with neither ENEC nor council representation. That group now is split into 2 groups as represented by 2 thick lines. So default cases in blue, it shows a distinct path going to disposition at the fastest rate. And excluding them, remaining ones are the red lines. And that shows it does not affect significantly the overall results. that the conclusion that ENEC cases take a little longer than the other cases. Moving on to the second question is a comparison of settlement rates with the cases broken out by the number of sessions that they have went to, and also broken out by cases with or without counsel. A previous meeting showed that ENEC settlement rate, different rates between represented and unrepresented cases. You can see here in the total bars, it's between 20 and 37% respectively. Further breaking out these cases by the number of hearings, it shows that more frequent hearings do not seem to affect the settlement rate, and difference between represented and unrepresented cases remain largely the same. The third question is to look at ENEC and discipline outcomes with or without counsel. So you have the 4 groups of cases. The top panel shows the number of cases. The lower panel shows those cases as percentages across the rows. So you can see the first row on the top panel, the total is 121 cases. That's all of those cases with neither ENEC nor counsel representation. And if you go down the column under disbarments, the 2 cells highlighted by the square, 26% and 17%, those are the percent of the cases in the first 2 groups without ENEC that resulted in disbarment. And I also highlighted 2 other cells. For the groups with ENEC, it shows 18% and 14% that resulted in private reproval. Now, in conclusion here, you can say that between cases with and without ENEC, those with ENEC had more cases disciplined. More cases disciplined by private reproval. While cases without ENEC, more of them resulted in disbarment. What we don't have here is case characteristics that it's likely to have affected whether they went to ENEC or not. And to the extent these are associated with the respondents' willingness or likelihood to participate in ENEC, these are confounding factors that are likely to be associated with the discipline outcome. And without the information about case characteristics, it's hard to isolate the independent effect from ENEC counsel representation and discipline outcome. And actually, when I removed disbarment as a category and compared the results, there is no statistically significant difference across all of the patterns. The last piece of information that I put together is related to a comparison between Corey and non-Corey cases. Corey cases are those came from the fingerprinting project. On the left panel, the chart shows percentage distribution in terms of a discipline outcome between Corey and non-Corey cases. So the top bar, you can see 24% of Corey cases resulted in private reproval. And on the other end of the continuum, you have 4% of those cases had disbarment. In comparison, you can see non-Corey cases, you have nearly 40% of the cases that resulted in disbarment. And more than 70% of the cases in Corey cases that have private or public reproval. The other chart shows criminal offense severity. That's the extent of the information we can categorize from criminal offense charges in the system to categorize them into the severity of misdemeanor or felony, and it shows the large difference between the two types of cases, where you have 92% of Corey cases, the highest the charge in terms of severity is misdemeanor. But non-Corey cases, it's an even split between the two severity levels. It only suggests that there is a relationship between the severity and discipline outcome. The other aspect of criminal charges in terms of the nature of the offense, I try to categorize them, but the information is not readily amenable to systematic categorization. So that's the additional background information about the charges that I wasn't able to take into account in comparing the discipline outcome between Corey and non-Corey cases.
Ron, can I interrupt you, just ask a quick question
Sure.
about the difference between the two sets of cases, the Corey and the non-Corey? Is it also true that the Corey cases tend to be older?
Yes, but not in this set. These are cases that were transmitted. The older cases, a larger percentage of them had outcomes less than formal discipline.
Okay. Thank you.
That's all. Any questions about any of the slides?
Ron, I have a question on the discipline outcomes. Following up with what Dag said, did you capture the number of cases that were transmitted that ended up in no discipline at all?
Let me think. No. I think what I focused on was to look at these 4 discipline outcomes: reprovals, probation, and disbarment. Cases that were dismissed, I have to go back and verify.
Ron, just generally speaking, though, we know that there were a couple of thousands of the Corey cases, though. Is that correct?
That we received.
Right.
Yes, but the proportion, are you talking about the cases transmitted?
I guess, right, the ones that were initiated in Odyssey for OCTC to evaluate whether there was any reason to pursue discipline on those cases. Is the Corey batch, I mean, is that where the Corey batch comes from? I was just thinking that that would be
Yes.
a very large number of cases on which it appears no discipline was imposed, at least along that particular spectrum that's shown here.
What's shown here are only a small subset of the Corey cases, much smaller in Corey than non-Corey cases that were transmitted. And in terms of a time frame, it'll be clear because we started the fingerprinting project in mid to late 2018. We started to have increase of Corey cases, about 2,000 in 2019 and 2020. And cases that I looked at here are cases that's transmitted and resulted in final discipline. And the time frame included only 2020, because in 2019, there were no Corey cases that have gone through the entire process. And as a result of that time element, and also the process of going through the evaluation and then making a decision about transmittal, the total number of Corey and non-Corey cases that went all the way to this stage is less than 200 altogether.
Right, and I guess what I was asking about in part, it was in part an effort to try to build on what Ed had asked about the cases that aren't shown here. So I think I'm just trying to get my head around what the universe is. And I don't know if this is what you were trying to get at, Ed, but my sense is that the universe of the Corey cases is huge relative to what actually got transmitted and then what you see here. And that the universe of the non-Corey cases is much smaller. But Ron, am I correct in that assumption? I know huge is a big term.
I was trying to get at the Corey cases that were transmitted and then ultimately no discipline.
Okay.
Right, that's a much smaller subset of the entire batch of cases. Any other questions?
All right. Thank you, Ron. So it sounds like we have another data request to bring back to the committee for the next time. So that, Ron, on that percentage on the of C cases that end up in private reproval, I think it was 5% on the slide. What's the number of cases in there that percentage represents?
Total number represented in the chart between Corey and non-Corey, it's 151, almost evenly split between the two groups, 75 and 76. So Corey cases, you have 24%, a quarter in private reproval out of 75.
The non-Corey cases, though,
non-Corey cases, yeah, 5% out of 76.
So that's like three cases. Okay. And then we don't know the number of non-Corey cases where there was no discipline that were transmitted. That's what we want to bring back.
Yes. I just need to clarify whether I captured them or I only looked at the cases actually resulting in discipline.
So,
okay.
So I don't know that you need to actually go to the effort of getting that information. I mean, I have a sense of it, and I'm not sure that it's going to make a statistical difference for the purposes that we've convened. My sense is that through Ron's good and hard work, what he's shown us through the metrics is that whether there's an ENEC or not an ENEC changes the time of the resolution by around a month generally, and that's not statistically very interesting. It's not that great a savings of time one way or another. That at least the data shows that with or without an ENEC may not have much of a statistical difference either. And so I understand that from the data that there's not what I expected necessarily, but I would also say that beyond the quantitative analysis, there has to be a quality analysis as well, and you need to look behind the curtain. So for instance, the easy one for me is that on the disbarment cases where the ultimate resolution is disbarment, there are oftentimes when at least defense counsel is involved, and the dialogue with OCTC is what's your offer at its disbarment. There's no way we will go below disbarment. You'll need to go to trial on this. There are many cases, not many cases. There are cases like that, and at that point, my typical response would be to speak to my client and let my client know that the bar has dug in their heels. This case will be going to trial. Let's not waste your money with an ENEC because it won't have any value. And so that's at least a a qualitative background that explains the data to a degree on those those kind of disbarment cases. It doesn't change despite all the hard work Ron's done and the statistical correlations, it doesn't change my view that it's still appropriate to have an ENEC process for criminal conviction cases just because of the carve out, not a huge carve out, but the carve out that allows for a private approval opportunity that's truly private for very low levels of discipline. So that's my general position, despite what I see the data indicating.
So I would just say that, first of all, I don't think it's possible to do a qualitative analysis of the ENEC process, but somebody can tell me if I'm wrong about that. But on the topic of the criminal conviction cases, I mean, to me, the cost of trying to amend a statute and the resources that it would take for OCTC to engage in the ENEC process in those cases really outweighs the benefit of basically 5% of non-quarry cases that resolve in private discipline. Because the reality is that once we get past the quarry cases, which we will at some point, really what our focus should be is on those non-quarry cases. And if you're talking about literally 3 cases that resolved in a private reproval, to me, it doesn't make sense to expend the energy and resources on trying to make a change.
So this is directed to Melanie and maybe Judge Wang, and I only recently learned about this, and it might be the much easier solution. And that is that I understand OCTC entered into a deal recently wherein actually what won't work, but I'll throw it out anyway, on an original case, a non-criminal conviction case, wherein the case had been filed, the agreement was private approval, and OCTC agreed to dismiss the original matter and then enter into a private approval situation. So for Linda's benefit, what that means generally is that after a case is filed and the respondent enters into a private approval, it would typically be a private approval with public disclosure. And I know that sounds really weird, but that's how it works. And so in the case that I heard of recently, it was a case that was filed, which would typically mean it would be a private approval with public disclosure. But because the case was dismissed and the private approval was entered into thereafter, it was a private approval without public disclosure, kind of a new animal. And so if we were to take that instance, and Melanie can confirm whether that happened or didn't happen, but I heard from several sources that it did, and not my case. And is there a way to undo a transmittal? And I'm trying to think out of the box a little bit, but if we could, if after the transmittal, we undo the transmittal, enter into a private approval so that there's not a need for public disclosure, and then I suppose seal the court record. Just throwing it out there. I don't know if it's possible.
And could I back up on one point real quickly, just because I wasn't sure about the numbers. Ron, would you mind showing the slide that shows how many days, what the additional time is? Because I understood that slightly differently. I didn't think it was just a month. I thought it was more time than that that's added.
Hold on. One 176 days.
176 days. Okay, so not quite 6 months.
That's correct.
Yeah, 5.5 or so. So that's, I don't know, how much of a consideration that is, but I think in terms of our thinking about it and whether it matters, obviously the qualitative issue is important, but we need to be clear on the quantitative impact here.
right? This is also just a further clarification. This is the time before the case is filed with State Bar Court. And then if you track a case age from beginning of the complaint all the way to final resolution at State Bar Court, a comparison will give you different results. And this is only comparing the phases prior to filing. And that shows about 6 month difference.
Okay. That's a big difference. Thank you. To my mind, it is.
To your point, Ed, I can't say whether that happened or not. We deal with hundreds of cases in State Bar Court a year, as you might imagine. You know, what you're raising related to C cases, I don't know the answer to that question. That's something I think that, you know, is a discussion for another time, because it's completely unrelated as far as I'm concerned to the topic, which is the ENEC process, and whether or not it should be included as part of C cases.
Now I think it's my turn to have the court's perspective. And I think I made this point earlier, and however the working group views it, but you can look at the numbers from the perspective of the burden of OCTC, but there's also the perspective of the burden on the court. So in my view as a hearing judge, the less cases that hit my calendar, in terms of the point in which I have to set trials within 125 days. I don't know what the overall numbers are, Ron, in terms of the cases that could have settled without me devoting that 125th day to those C cases. So in other words, to me, the dismissals are important, because if both, I have an O case and a C case that are both hitting on day one, they are both competing for that 125th day. So in terms of the efficiency overall, I'd rather have less cases competing for that 125 days. That's why I think, generally speaking, I don't think the hearing judges, or I personally would not oppose an ENEC process for those for criminal conviction cases for that purpose. If the overall health of the court numbers, the efficiency is to clear out cases as quickly as possible, the less cases choking that timeline is better in my view. In terms of Melanie's point about costs for amending, I understand that there is a process, and I don't dispute that it's a challenge. But if you're drawing an analogy between conviction referral matters and O cases, you have OCTC investigating both. I know it's a shorter, truncated timeline for the C cases. In other words, you're pulling the docket, you're getting the information. That is still an investigation period, but that it doesn't start until it's, well, actually, Melanie I won't talk about how the sausage is made, but once it's transmitted to the review department, OCTC is kind of scrambling. So there is kind of a little bit of a catch up, and that's when the investigation kind of begins. So I don't understand why, philosophically or on a policy level, why can't that process be private in the same way in O cases? Because, and Ed may have his view of it as well, but oftentimes I am conducting the DSC and I ask OCTC privately, do you have a witness? Do you even have the police report? What are the facts and circumstances you can show besides a, you know, run-of-the-mill DUI with no injury? Is it worth clogging the court's docket on the 125-day timeline? Anyway, that is the view, my view, that those are open questions that aren't captured by these numbers that I'm kind of throwing out there for the working group to consider.
Well, to some of those points, and frankly, those are conversations that we've even had at the bench bar when you're talking about the 125 days related to C cases in particular. And, for me, the fix is not to add in another process prior to transmittal, but rather to change the rules related to C cases. Now, I might be wrong about this, but I think that the 120-day is an internal time guideline for the court. I don't think that that's statutory, for example, unlike OCTC's backlog statute. So it seems like there might be some room there. The other things that come to mind are that, the C cases are, for example, as you know, and it's not just C cases, but discovery is limited. So we don't really even have an opportunity to, for example, take a deposition. In a C case, it's particularly impactful. We can, of course, ask the court, but we have to show good cause. Unlike in original cases where we could be taking a deposition prior to filing. So, to me, if we want to address some of those issues that you might be feeling, and understandably, we ought to be focusing on changing rules related to how C cases are handled after transmittal.
Which is sort of my proposal last time, the elegant fix, or what I was calling an elegant fix, in terms of capturing the language under 6086.1, somehow working that process. To me, it's not a big change that on the referral, that remains private until it's referred for hearing in the hearing department. So I think there's a solution that does not involve this grand statutory change that creates a burden on OCTC.
And Judge, I'd like to ask Melanie on that point. Melanie, you mentioned that there's a great cost that goes along with getting a statutory change enacted. And I'm curious about that for two reasons. One, I understand the way that this process will work is that at the end of the 18-month period of the commission, that this will go to the Board of Trustees. The Board of Trustees will vote. Then they will engage their legislative lobbyist, that the lobbyist will then present all the recommendations from the Board of Trustees in one package. And so in that regard, at least it's my understanding that there shouldn't be any additional cost because we're going with a package of proposed legislative changes, if any, and that it's not, and this wouldn't be an additional cost. I mean, am I misunderstanding that on any level?
Well, when I said cost, what I meant was twofold. One is that it does, I don't know what the panoply of possible statutory changes might be coming out of the ad hoc commission as a whole. But I imagine if there are several, then they might be prioritized in some way. And I don't think it's necessarily an all or nothing endeavor. And to me, when you're talking about a change that really is going to only impact a very, very small number of people, it doesn't make sense to put it high on the priority list. And also it's a cost for OCTC to engage in more settlement discussions prior to filing, prior to a transmittal that could be protracted. In particular, in cases that are going to result in public discipline in any event. So as we saw with Ron's other data related to how long it takes matters to resolve once you add in an ENEC process or an ENEC process plus respondents counsel, you see that it takes significantly more time. And that is a resource cost for OCTC.
Okay, so where do we go from here?
Well, that's where I was at. And my initial questions were trying to bring the C case question, full circle to where we can either get consensus among the working group that this is something we want to move forward on, or is this something that we don't want to move forward on? And if there was any other information or data sets that need to be done. I don't know if there is, because it looks like it's a small amount. And I kind of understand where Ed is coming from, where Melanie is coming from, where Judge Wang is coming from. And then Linda, I don't know if you have thoughts on this. I'm trying to kind of wrap up the C case discussion and whether or not we're going to move forward with a recommendation. If there is extra data, we want to wait and find out if the pool gets any bigger by those that aren't moved forward in discipline, that Ron is going to confirm, or do we have enough data, we've looked at it now, that this is something we want to pursue?
And just to clarify, the additional cases is not so much the cases that didn't move forward, right? It's cases that's been transmitted and resulted in non-discipline.
Yeah, right.
Yeah.
Because right now we're looking at a pool, from what I see, of non-Corey cases, which is, Corey is the one-time event, the fingerprinting event, that is going to go away. The non-Corey cases are what we're going to look at going forward. And we're just trying to, the total pool right now is, from what you studied and presented, is 3, from what I'm gathering. And then we don't have information on those that were transmitted and not move forward for discipline. So that could increase that by some amount. And so that's
generally in any pool of the cases that's been transmitted or filed with state bar courts, cases that's dismissed accounts for less than 2-3% of the overall total. I'm not sure about if there's a difference between criminal and other matters.
So Justin, your point begs the question of what is the purpose of the working group? And in that regard, I'm not, what I'm gathering is that at least out of this group and this discussion, there's not a consensus. And so there's certainly a value in dialogue. And I've learned a lot through the presentations that have been made and through the views that have been articulated. That said, I suppose that without having a consensus, we go back to the subcommittee and we say, these are the discussions and the dialogues that we've had. This is a summary of the differing positions, and then have a bigger colloquy amongst the bigger group, and then ultimately take that to the entire commission, or at least we've dug into it and understand the statistics better. But I don't think that this group needs to have an answer, because what I'm hearing is that we don't, and that we have differing positions. I probably softened my position in terms of where I started, but it hasn't changed.
So I was trying to get consensus. I was trying to kind of poll the working group to see if we could arrive on consensus, because I heard your point of view, Ed. I hear Judge Wang's point of view about the constraints of cases, the 125 days. And you even talked about that it would probably, if we decided to do something on this, it would be better to look at the 86.1 versus the 6101, giving more time to transmit to have it. But it would be better that we kind of carve out time where it's not public until it's forwarded to the hearing department, I think is what one of the suggestions that you just talked about. And so I don't know, is there consensus on something to move forward or not? Because I haven't heard from Linda yet. And I think ultimately, if there isn't consensus in a working group, and we are 4, so there could be ties or something, that Ed, we can present all the discussions, and we can present the 2 viewpoints for the full ad hoc commission, and they can decide to go forward. Because it's not like there's consensus to do nothing. There's just differing on, it's kind of split. And so I think when there's differing points of view, then the working group will probably present each side to the full ad hoc commission, and then they can we can have a discussion there. Ideally, these working groups would kind of formulate things and we would come up with ideas and have a presentation, but it's probably not going to happen in every area, and we will have differing opinions, so there we can present both of those opinions. But I'm just curious if this working group, if there's any consensus at all on the C cases.
Let me just give you sort of my perspective on this discussion. First of all, I do look at things from a fairly programmatic point of view, since that's my background. And so looking at the bigger picture is sort of my viewpoint on it. And the amount of time it takes to do the ENECs, the amount of delay there is to filing, particularly where you have that reporting requirement concerning the backlog, is one that weighs fairly heavily, in my viewpoint, against the competing consideration of the few cases that end up in private reapproval on the Corey cases. So when I look at just kind of those two factors, I balance that, and it balances in favor of leaving the process as it is and not including an ENEC with those criminal conviction cases. If you were to change it in some way that they're not public versus, as they are now, I wouldn't, that part wouldn't really bother me. It's just the giving them the ENEC really slows things down, and they're, not that valuable in terms of that interest of private reapproval as far as the big picture is concerned. Okay.
So that tells me that we probably won't get consensus on this working group. And so that the plan to go forward, and this is subject to change, but what I'm thinking right now is that this working group can say that it didn't come to consensus over changes, but certain members of the working group would like a change to the ENEC process that includes criminal convictions, and is the focus area, so we can kind of detail out a little bit, is that we would go with Judge Wang. I mean, Ed, are you comfortable with what Judge Wang was thinking about in terms of changing it to keeping it private until it gets referred to the hearing department? Is that kind of change, or is there, I mean, the two changes seem to be allowing more time for the transmittal so the ENEC can take place, or changing it as when it becomes public. Those are the two different areas of focus in the Business and Professions Code that would need to be changed.
Right, and there might be more consensus than you think, because I concede that Melanie's point that there's greater cost and there are greater resources that are involved in order to create a situation where there would be a private approval in the context of a criminal conviction. But my perspective is that the greater cost and the greater resources is worth it if there's even one case that's affected. And so I'm not moved at all by the fact that there are not enough matters for us to make a change. Like I say, even one is enough to make a change. And so in that regard, yes, cost and resources and length of time, the data says what it says. I understand that. I appreciate that. It doesn't move the needle for me. And yes, the elegant fix from Judge Wang is something that I would support.
Okay. So I think I have what I need in terms of direction, in terms of how we are going to bring this back to the full ad hoc commission. And I will work with the members of this working group once we eventually get there in a couple months, to make this full presentation. So both sides are represented when we present it to the full ENEC. So I think that kind of shuts the door on the C cases. We have a plan of action for that. And then it kind of opens, are there other changes to the ENEC that people would like to discuss or present? And obviously we only have 13 minutes left for this meeting, but we have spent a lot of time on the C cases a piece. And I just was wondering if there are other areas in the ENEC process where changes could be beneficial to make them more effective. And so that's why I'm throwing it out to the working group now, and we can maybe just highlight them and then talk about them next time. But if there are other areas where the court or Linda or Melanie or Ed that we'd like to focus on in this working group.
So I would just say for me, and I know that we've had a lot of discussions around the perceived benefits of ENECs, but seeing the data indicating just how much more time it adds, and the fact that in many of those instances, it still results in public discipline, which to me, the ENEC process is really supposed to benefit those whose cases will result in private discipline or no discipline. What I would like to see is a change to the rule that limits the ENEC process. And by that, I mean, for example, that the parties go to an ENEC, but that it not be protracted, that there not be multiple ENECs, and that if the hearing judge, for example, who's conducting the ENEC makes a determination, for example, that the case is likely to result in some form of public discipline, that OCTC could go ahead and file the notice of disciplinary charges. I think that helps in terms of moving the process along. It certainly benefits OCTC in terms of our time standards. It allows for public notice of charges against a respondent earlier in the process. And there are still opportunities along the way for the parties to engage in settlement discussions. So I would like to see some kind of change related to that.
My pushback back on that is you have to trust the process, and the process here includes the judge and the court. And so it's not as if I as a defense counsel can demand a second ENEC. There needs to be a coordinated effort between OCTC and the judge. And if the judge is not agreeing to a second ENEC, it's not going to happen. If OCT is not agreeing to a second ENEC, it's not going to happen. So it's not just driven by us being the defense counsel.
Well, at least, Melanie, at least from my perspective, I never demand a second ENEC because I don't think I'm empowered to do that. I only conduct a second ENEC when everyone agrees. So I can only talk about my perspective. So I don't know how much the numbers get inflated in situations where a judge, I don't want to use the word forces because I don't think my colleagues do that either. A second ENEC is forced. So the only times I will conduct a second or third oftentimes is when the respondent's pro per and they haven't got their stuff together, or everyone agrees that it could benefit with another ENEC. So I'm just trying to directly answer what you were raising.
Sure, and perhaps that's true for how you've conducted them. But I will tell you that I am aware of more than a few examples over the past few years where OCTC has been ordered to multiple ENECs. And we have been faced with occasions where we have filed an NDC because we don't agree. And there's been a motion to dismiss because of the lack of conclusion of the ENEC process, and the NDCs have been dismissed. So perhaps that's true for you, but it has been a troubling number of times when we have been prevented from moving forward in filing NDCs.
I'm sorry to hear about that experience. That's certainly not mine. That's something we definitely should talk about in the bench bar committee meetings if that is true. But at least from my perspective, that's not my experience.
During the discussions, I heard many times that part of the reason, or it seemed like a big part of the reason that ENECs were held on more than one occasion was with respect to the pro per respondent attorneys, because they don't really know the process and the timelines are very short. They get this notice in the mail and they show up and they don't have their stuff together. So another ENEC is required. So one thing that I've thought about in terms of changing the process that might be beneficial is to require, not necessarily require, but invite attorneys who are pro per, or even those who have an attorney, to come into an orientation process before the ENEC is held. And I think you've talked about something like that in the past, but to have them come in and almost like, when you go in for jury service and you sit in the big room and the judge tells you all about, jury service and that sort of thing, sort of an orientation as to what the ENEC process is. Tell them that you get one chance to come before the judge and bring your mitigation evidence, your rehabilitation evidence, gather it all together, look at the disciplinary guidelines as to what those items are that we consider, assuming it's in there. I don't know if it is actually, but it is in a lot of the ones that I've dealt with. And, pull your stuff together. You're going to get one chance to make your pitch and have this discussion and be prepared for it. And it's going to happen in 30 days or whatever the process might be. So that's an idea that I have to offer to the ENEC process that might make it more efficient. I agree that it shouldn't be protracted process when the process is really to screen out cases that shouldn't be filed in the first place. That's my understanding of what the process was meant to provide was, a judge to take a look at it and almost like a little mini preliminary hearing, be able to say, no, this case has no merit, get it out of here. So it's really evolved into more of a settlement process, which is great. If you can settle cases early, that's always a good thing, but it shouldn't be a protracted settlement process when you have this competing interest to having to get those cases filed and give notice to the public to protect the public and also to, meet your time goals. So that's, again, a perspective from another arena.
Linda, I think you summarized that really nicely. There is a lot of competing interests and difficulties, and that's why I do take my role very seriously in terms of the neutral evaluation. And to be honest, Melanie, you folks live with the case much longer than the court. We get the letters 3 court days. Okay, so Linda, this is why I don't know where the fix is. Okay, so once you make your request, the court's supposed to hold it within 15 days, but gathering both parties and the court, I'm going to start a trial at 9:30. But the fact that, we have impacted calendars, so to fit it within the 15 days is already a challenge. Then on top of that, OCTC gets their position letter 3 court days before my hearing with a draft NDC, and the respondents don't have to propose a settlement offer. So I'm already flying in, kind of half blind in this last minute, kind of slipshod way, and I'm trying my best to give both parties a neutral evaluation of the charges and whether or not they stand. And frankly, I'm not always able to do that, Melanie. And that's why sometimes, you know, if it is a, you know, I think I might have, you know, plug your ears, held like 3 ENECs on one complaint that was 30 pages long, right? And it, you know, for me to do my job and to, you know, honor, you know, what I'm supposed to do, it's difficult, and there are competing interests, and I understand it needs to be public, and I understand the public has a right to know, but at the same time, I don't want to give an inaccurate evaluation or not, you know, give an evaluation at all. And sometimes that's what I'm faced with the timeline.
And Linda, Judge McGill has been working on some self-help materials that I don't know if are ready to go, but they are from what I've heard, going to address some of the things that you talked about and try and prepare, you know, the unrepresented attorneys for that first ENEC. We don't, obviously they haven't been put into place yet, and we don't know their actual impact and how useful they would be versus like a meeting or an orientation. So I'm not saying that that's not a good idea, but there at least is effort to kind of bring the unrepresented attorneys to the first ENEC better prepared with those materials. So we have 2 minutes left. I think we've gone as far as we can go today. I will reach out to try and plan our next meeting and talk about potential other changes. If there are other changes, please feel free to email me so I can be better prepared, and I probably will reach out to you as well. But I really appreciate the discussion today. And unless anybody has anything else they'd like to bring up now, I think we are done for today.
I don't, just, I wanted to thank Ron for all your hard work. Thanks. That was really enlightening.
Yeah, thank you.
Yes.
Everyone.
Thank you.
Right.
All right.
Thanks, everyone.
Bye, everybody.
Thanks. Bye-bye.
Bye.
Bye.